but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. All right. And so Mr. No was previously in court in cause numbers 25 DCCR 0386 and 0387, entered pleas of guilty to intoxication, manslaughter, as well as driving while intoxicated with a child less than 15 years old. That was an open plea to the court. We had gotten started a little bit on this hearing, and then I reset it so that the state could, or anybody could, bring any witnesses with regard to statements in the PSI and sentencing. We've all had an opportunity, correct, to review the PSI?
The state has. Yes, Your Honor.
Other than what we've already discussed and what the defense has filed with regard to response and objections, anything else with regard to the pre-sentence report?
Not from the state court. Not at this time, Your Honor.
Okay. There was also a letter from Joyce Barnes, the mother of the defendant, and I have that as well.
Your Honor, I think we had also previously filed letters of support, which the court had reviewed.
Okay.
The state calls Trooper Angel Campos.
Trooper Campos?
Trooper Campos, how are you employed, sir?
I'm employed to the Texas Department of Public Safety.
And how long have you been with DPS?
I've been with DPS today almost 3 years.
Okay. Your training and background, of course, includes the academy. I understand you also have some military background as well. What does that include?
I do. I'm working on my 11th year serving in the Marine Corps, and currently I'm a Staff Sergeant E6 in the Marine Corps today.
Describe for the judge what you observed when you made the scene.
Initially, when I made the scene, I was expecting, like I was dispatched to 2 vehicles. Then I later found out the 2 vehicles that I rode up on, one was the deceased's vehicle, and the other one was the witness that witnessed the entire crash. I didn't see a third, but I couldn't really comprehend what had happened because I couldn't find the car that did everything. And then I later found out through on-scene personnel that the vehicle that caused the crash was further down the road, upside down.
Did you make contact with the driver or the operator of that vehicle?
I did.
And was he identified?
He was.
Who was he identified to be?
Ray Anthony Noe.
Okay. And was the vehicle that that the defendant Ray Anthony Noe was driving, was it also, did it have any passengers?
This is one of those cases where the facts alone are enough to make your stomach drop. A drunk driving crash, a child in the car, and a life lost. But what makes this hearing even more intense is that the defendant already pleaded guilty. So this isn't about whether he did it. It's about what kind of punishment fits a decision that can never be undone. And as the court starts reviewing the case, you can already tell this is going to come down to one question. Does this man deserve probation? Or prison?
It did.
And how many and what was their age in relationship to this defendant?
It was his child. I want to get the age exact. I don't remember exactly, but he was around, I think he told me at the scene here that he told me he was 9 years old.
Okay. And through your investigation, did you determine if that child was restrained in that vehicle during the crash?
Yeah, the investigation determined the child was not restrained at the time.
When you made contact with this defendant, we're not going to spend a lot of time on it because he's already pleaded guilty, but nevertheless, you observed signs of intoxication, correct?
Yes.
Did he refuse or did he consent to a blood draw?
He refused.
And you obtained a blood search warrant, correct?
I did.
And his blood was drawn pursuant to that blood search warrant.
Yes.
What I'd like to ask you about next and explain to the court is this defendant's demeanor. How would you characterize this defendant's demeanor there at the scene and at the hospital as well?
So his demeanor.
Your Honor, I'm going to object to this to the extent that he's required to. I don't have an objection to him observing what his observation, but to the extent he's going to opine, we're going to redo our objections that we've already made in our response to objections.
That's overruled. He can testify as to what your opinion is as to his demeanor. That
when officers describe scenes like this, you realize how chaotic these moments really are. An overturned vehicle, a child inside, another person dead. These aren't just legal details. These are the kind of seconds that change entire families forever. And the fact that alcohol was involved makes the situation even harder for a judge to ignore. Because once intoxication enters the picture, the law becomes a lot less forgiving.
evening.
Please go ahead and answer truthfully.
The demeanor on that night, he refused to comply with almost every order we gave him. We had tremendous amounts of patience to try and do our job, and he made it every bit difficult, to include the omittance of, allowing us to prove. I even asked him on scene if he could let me do centralized field sobriety test so we can rule out his intoxication, and he refused that too. Tried to give him a chance there. Tried to give him a chance to consume blood, and he refused there too. Did every trick. Well, it appeared like he was trying to buy time for himself, and he, through my training and experience, we kind of pick up on tricks that DWIs do, and it appeared like he was utilizing everyone he could at the time.
Yeah, and I'm sorry to interrupt, but we're talking about more than just a refusal or more than just not cooperating, correct?
Yes.
I mean, how would you describe that to the judge?
I would object to leading on that one, Your Honor.
Overruled. Go ahead.
Everything on that night, he, from what I can recall and remember, everything he mentioned or asked, none of it was about the other parties. It was all either about himself or his son.
This is where the case starts to get worse for the defendant. Not only was he intoxicated, his own 9-year-old child was in the car, and not even wearing a seatbelt. Then the trooper says he refused sobriety tests, refused blood, refused orders. Legally, that doesn't prove guilt by itself. But in a sentencing hearing, behavior like that can shape how the judge sees you. And right now, it's not looking good.
Trooper Campos, at this point in your interaction with the defendant that night, you'd already informed him that someone had died as a result of that accident, correct?
I did.
Before you informed him, and even after, did he ask or inquire of you what happened to the other individual or individuals involved in the accident?
Not that I can recall, no.
Is it fair to say that his focus was just on himself throughout your entire interaction with him?
Yes.
Pass the witness judge.
Thank you, Mr. Coleman. Mr. Franklin?
I have no questions for this witness, Your Honor.
All right. Any objection to Trooper Campos being excused?
No, yeah.
None, Your Honor.
Thank you, sir. You're excused.
Yes, Your Honor.
He has no further witnesses in the state arrest judge.
All right. Thank you. Any witnesses, Mr. Franklin?
Your Honor, I advise my client about his constitutional rights to testify or not testify. I've advised him against taking the stand. He's decided not to take the stand. I just want to make sure that we put it on the record that he has been advised and he has chosen not to take the stand, Your Honor, and testify. I would like to offer closing.
All right. Thank you.
Just-
And so, Mr. No, you have every right to testify if you would like. Obviously, you've already pled guilty, so there's not an issue with regard to, whether you did it or not. There's been a plea of guilty. If you've talked with your attorney and it's your decision not to testify, is that correct?
I just wanted to apologize, ma'am.
All right.
Um,
That's good. Thank you. If you want to testify,
but
you can get up on the stand because you'll be subject to cross-examination. So you can't just make a statement to
Okay.
me. If you want to get up on the stand,
Mm.
I'll swear you in and then the attorneys can question you.
This moment is uncomfortable, but very real. You can hear him trying to apologize, but the judge stops him. Because in court, you don't get to just speak whenever you want. If you take the stand, you can be cross-examined. And you can almost feel the regret here. But regret doesn't erase what already happened. Now the only thing left is the sentence.
no, Your Honor.
Okay. All right. So then I will, I guess, Mr. Franklin, you may proceed with argument.
Thank you, Your Honor. Would you like me to do it here or at the? It doesn't really matter. to me.
You're fine there.
Okay.
That's wherever you're more comfortable. It's
Your
fine.
Honor, we've made our arguments and our motions and responses. I did just want to comment a little bit on the evidence from Trooper Campos.
Sure.
And point out that some of the language used by him about the worst case, et cetera, he just testified he's been with DPS for 3 years. He would have been with them around a year at the time. What the evidence actually showed was Mr. Noe saying please and yes, sir, that he wanted his son to be okay. It was really only in the last video that he had finally learned that he testified that Mr. Johnson had passed away in this case. There was no testimony about him having any knowledge of that in the prior videos. And the question was, at this point, did he know? And he said yes, but there was no testimony that he did know in prior ones. And I think the evidence would reflect that as well. The other thing is, of course, the court takes into account all the evidence. Part of the statements about the reprehensible nature of my client's actions, about how he was belligerent and reckless, I'm not sure that any of the evidence produced by the state, particularly on the scale of belligerent and reckless defendants, actually rises to that level, and nor is his decision to exercise constitutional rights belligerent or reckless. And for these reasons, we ask the court to consider or not consider the statements regarding religion, or at least consider the evidence that was presented for what it was. And otherwise, our arguments have been in our written motion, Your Honor, and we've presented information to the court, including the letter from his mother, the letters of support, and the information about his sobriety since the accident. And for these reasons, we ask that this court put the defendant on probation, Your Honor.
The prosecutor is doing exactly what prosecutors do in cases like this, reminding the court of every detail that makes the crime worse. High blood alcohol, child in the car, someone dead, and even a past case involving drugs. When those facts stack up like this, probation becomes very hard to justify. You can see the judge listening carefully here, because this is the moment where the decision starts forming.
Thank you, Mr. Franklin. Mr. Coleman?
Thank you, Your Honor. Likewise, I would rely on its pleading in its sentencing memorandum. Your Honor, the court's read it, so I'm not going to belabor it. If I could just briefly hit the high points, Your Honor. This defendant's blood alcohol was a 0.149, and he had his son, a child passenger in the vehicle, while he was driving at a 0.149, and that child, his son, who in the video he professed that he cared so much about, was not restrained by a seatbelt. Judge, we have a situation here, but for the grace of God, that his son didn't die, and that more people on the roadway that evening did not die. Judge, I think what's aggravating in this case, and I attached a copy of the safety paperwork to my sentencing memorandum, is that this defendant, as part of a probation for felony possession of marijuana back in 2013, was assessed 7 months of safety. And I would think that after 7 months of safety, he would have addressed what, if any, substance abuse that he may have had, that including alcohol. And I find that him finding himself in this situation, a more egregious situation, could have been avoided had he taken full advantage of the rehabilitative effect of safety. Judge, Mr. Johnson, the victim in this case, Douglas Johnson, got a death sentence, unfortunately, that day, Judge. And I think justice in this case would not lend itself to this defendant walking out of his courtroom today on probation. I think justice in this case would be for this defendant to spend some time in prison, Judge. I'm asking.
This is the part of a sentencing hearing where everything slows down. The judge isn't just reading a number. She's explaining why. And what she says here matters, because it shows how the court sees the difference between a mistake and a crime with consequences that can't be undone. You can already hear it in her voice. Probation is not happening.
For prison on the closer end of towards 20 years. Thank you, Your Honor.
Thank you, Mr. Coleman. Anything else?
Nothing from the defense, Your Honor.
All right. So, Mr. No, these are some extremely difficult cases. When someone loses their life because of your actions. And Mr. Franklin made the arguments and did a great job with his memorandum to the court, trying to point out things and make me think about things in a certain light. Obviously, you didn't get in a vehicle with the intention to kill someone that night, but you did get in the vehicle knowing you were intoxicated with your 9-year-old son, and you ended up killing someone. He also made an argument about that safe P and some of that documentation and the fact that was old, and I shouldn't take that into consideration. I think it's very relevant, though, that you have been through treatment. Even though it's been a while, you obviously had some issues, went through treatment, a serious treatment program, where you're in custody in treatment. So you have felt what it's been like to be in custody and still committed this offense. I don't think probation is appropriate in this case or either case. I'm going to find in cause number 25 DCCR 0386. Again, you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of intoxication, manslaughter with a vehicle. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0387, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you were in custody that the law gives you the right to receive. I'm going to hand you in each of your cases or to your attorney. He'll give it to you, the trial court certifications that shows these weren't agreements. You do have some limited rights to appeal, and you could talk to Mr. Franklin about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can also talk to Mr. Franklin. Mr. Franklin, if you'll grab those for your client. Thank you to the troopers for being here, and court will be adjourned.
15 years. In a single moment, this man lost his freedom. Another man lost his life. And a child will grow up remembering this night forever. Cases like this are hard to watch because nobody really wins. The court calls it justice. But for the people involved, it's just consequences. And it all started with one decision: to drive when he shouldn't have.